Hello there and welcome again. We're on module 5, training number 3. Now, let's talk about Tarasov principle and court cases. Here is a prime example that I don't really care what school you attended, they did not talk about specific court cases. And if you did not attend a course review, it is unlikely that you would get those questions right. From this content alone, it's likely that you get maybe three, four questions, maybe five, because we are going to cover super high yield content in a very short time period. And hopefully you understand and write it down each line. It is so important. Okay. So here we are going to discuss the Tarasov principles in court case. There are several court cases that you should be aware of. And by mastering them now, you'll be an inch closer to your PMHNP board certification. This is our roadmap from module 5. Training number 3. So, what is the Tarasov principle, right? Well, let's start by saying that I don't like to memorize it, the two names, the two legal names, okay? The ANTC, the PMHNP board certification, it's unlikely to say Tarasov versus O'Connor. So in that case, instead of saying hey, let's go ahead and memorize Tarasov versus Regents or O'Connor versus Donalds. I just say the O'Connor case, the Tarasov case, right? So that way it saves me a little bit more brain power for other useful information. We are going to discuss lots of information, and if we can condense this information in a way that you can remember, it will serve you well. So the Tarasov principle. Basically, this happened in 1976. Not well, a little while ago, a little bit older than my age. By a couple years. So this is when you hear the Tarasov principle. I want you to think about duty to warn. Tarasov is the duty to warn. Warn who? Potential victims of imminent dangers of homicidal clients. Right? So, however, does not apply for every state, right? And it requires enforces the not every state enforce this principle. So what does it mean, right? This is a national case, but every state, as we mentioned, right, the scope of practice is a bit different. So if it doesn't apply for your state and we are taking a board certification, so it is always safer. Two things: when you see duty to warn, if the question says, hey, contact X, Y, and Z, or contact the patient, the possible victim, right? I want you to think of this as, does it apply to my state or does it apply nationally? Okay, because it could apply to a state, but we're taking a national board certification. So the duty to warn is important to know what principle that is, because it could be a straightforward question. Which of the following law cases is inquiring about duty to warn? And that could be the Tarasov principle. However, in your action, I want you to think of this two answers. One, you could always contact the state board of nursing. Why? Because it directs the scope of practice for your state, what you should or should not do, the roles for the state, right? So that can be a possible answer. Another possible answer could be call the police. You can never be wrong with calling the police. Call of the police, it's always a safe bet, generally speaking. Okay, every question can have its twist and intricacy, but calling the state nursing to find out what you should or should not do, it's always a possible answer. And again, calling the police, it's always a safe answer. But why? Well, it's your right to call the police. You have the right to do so. Okay, so when you hear Tarasov, I want you to remember duty to warn. But I also want you to remember that it does not apply nationally to every single state. Okay, so in the last few decades, luckily, the law has been more towards the patient to improve and side towards the patient health care mental health, meaning that we no longer can confine one without a reasonable imminent dangers. So here are some examples that you should really write it down right now. What is habeas corpus? Habeas corpus is a unlawful detention without a due process, right? A lot of statutes regarding mental health patients against being detained or hospitalized, which is in the IBH unit, is the same thing as being detained. It's unlawful. So the patient has the right of habeas corpus in case if he or she believes as being unlawfully detained. O'Connor case. Again, I'm not going to go over O'Connor versus Donaldson. I'll just say the O'Connor. So let me talk about O'Connor. It's a really classic in mental health. The O'Connor case, basically, it was a guy, his name was O'Connor, and he was hospitalized for 15 years. During this 15 years, he wanted to go home and he couldn't. The hospital said, hey, you're not good to go home, so you cannot. You're mentally not well, not just say mentally crazy, he's just mentally not well. So until that the patient said, you know what, I had it for 15 years, I'm not in imminent danger to myself or to other. I may have schizophrenia, I may have some issues, but I will request the court to revise my case. So the court went along and revised the case and said, you know what, it's your legal right to be released since you are not in imminent danger to self or others. So that is the O'Connor case. The person was hospitalized or detained against his will when he was not um, he could survive outside on his own. He was not a danger to self or others, so it became illegal, unjustified to involuntary hospitalize someone that is not an imminent danger to self or others. So based solely on the mental health condition. Now, patient's right, right? When you hear patient's right, I want you to think of at least two things right away. Write this down. This is important. The patient has the right to confidentiality, right? Has the right confidentiality. Patient has the right to least restricted environment. So patient has the right to confidentiality and least restrictive environment, and also has the right to informed consent. So by doing informed consent, we allowing the patients to do as they wish with their own treatment, right? So informed consent, least restricted environment, and right to confidentiality. So add the confidentiality to the PowerPoint there. Now let's move on to the Rainey versus Klein. For some reason, this one I like to say both, but Rainey case. So the Rainey case says the patient has the right to refuse treatment and use an appeal process. Okay, so especially with medication, has the right to refuse the medication if they don't want to. The Roger versus O'Kane, the patient has the right to refuse treatment, but the guardian may authorize the treatment. So if the patient says, hey, I'm 17 years old and I live under my parents' housing, I don't want this medication, I don't want this treatment, the patient has the right to do so, but the parents come along and say, hey, you need this treatment, so therefore the patient will get the treatment that the parents consent, since the parents are the guardian of the patient. Durham versus USA. Durham, it was an individual may not be criminally responsible if the unlawful act was the product of mental illness. So I want to stop right there because right now I can imagine you or some of you guys raising your hand and start like thinking outside of the lines. And well, can the patient, if the patient committed a crime, let's say if the patient commits a crime and he was not on his right mind, is he responsible for the act? Or I want you to stop. Okay, right now I'm not a lawyer, neither I am versed in laws, but that's what the Rainey that's what the German case says. right? So I want you just to read the definition and keep it as is. Don't complicate on your head. Don't think, well, I know someone that was not, it was in a manic episode and committed this crime. He still went to jail and he still was persecuted. And okay, we know cases like that. But for the test purpose, think of this way: the German case is an individual not criminally responsible if the law act was the product of a mental illness. Period. I know. Sorry, guys. I know lots of questions will come from this. I just want you to emphasize the point what the law says. Now, there'll be several cases that we know doesn't really apply, but keep it simple. We are just going in a very a high level here. We're not going in deep details in the cases that you know or cases that I know to not further complicate for your board preparation. How about Ford? So the Ford case was the patient must be competent to be executed. Okay, again, it can be one of those cases. The patient is highly schizophrenic with psychosis. Can they be persecuted or not? We're not getting to this detail, but the fourth case says the patient must be competent to be executed, killed, or you know what have you. It must be competent. How about the Stark Law? When I say Stark Law, I want you to think about under the table, right? Getting something under the table, benefiting under the table when the law is specifically against it, right? So basically, with the Stark Law, it cannot self-refer patients for a monetary gain. For example, here, huge uh, in life and possibly on a board test is a pharmaceutical company pays off a student loans. Then you work for the pharmaceutical company and provide samples to patients. You provide the company sponsored education and get paid, or simply in the more settled case, let's say the pharmaceutical company paid my education, so therefore I am very biased against a medication and I only prescribe the medication and SSRI when there are six other possible choices, but I only stick with one because their pharmaceutical company paid my education. So this is a clear example of Stark law. You should write this down. So what is the American Disability Act of 1990? Or better known as ADA in 1990. It stops unfair treatment of people with disabilities. So it puts a stop to it. There's some exception, but we are not going to get in the nitty gritty details. So what kind of unfairness is the American Disability Act is trying to prevent? Job hiring, firing, or promoting due to a disability. Places can be restaurants, stores, and transportation, so programs, school, library, governments, etc. Now, it aims for equal opportunity for everyone. So again, ADA, Americans with Disability Act 1990. So it's ADA is a civil right law for people with disability for the entire lifespan. The ADA people with disability are entitled to help or reasonable accommodation. So what is reasonable accommodation? So let's say that I work for a big company and I need a specific chair because my back hurts. I have a disability. So that specific chair costs money. So the company is required to purchase the, the specific chair rather than firing me because I cannot use a regular chair. But there is application to the how many employees, how big is the company, and so forth. But we are not getting to this detail. But this is what reasonable accommodation is, right? So people who in previous generation have been institutionalized can now be productive members of society with some of these accommodations available. So that is the goal of the American with Disability Act, better known as ADA. Now, as I like to do, there is always a mnemonics here. Again, guys, if the mnemonic is helpful to you, keep it. If it's not, throw away. I really like this one. So let's go see it. So the mnemonic here is a torpede fuzz. I like to call it the torpede fuzz. And the T is for the Tarasov principle, which is duty to warn of potential victims. How about the H? Orbis corpus, potential protection against unlawful detention. O, the good old Connor, the guy that was arrested, not really, he was hospitalized or detained without imminent dangers to self or others. So O'Connor cannot confine mentally ill against their will if they can't survive outside. How about the R is for right? The patient's right, least restrictive environment and informed consent. Okay, informed consent. And the P stands for the reigning versus claim. It's the right to refuse treatment. Okay, so we'll call that the perfuse. Okay, and I'll go over why I call it the perfuse in a little bit. I have a little story to put all this together so you'll never forget it. Okay, now the D is for the Durham, not criminally responsible if the act was due to mental illness. Do you remember the next one? The Ford case, right? Ford must be competent to be executed. How about the S? I call it the self-refer, right? Which is the Stark law. Can't self-refer for monetary gain. And finally, the S for simple, which is the conflict of interest with the pharmaceutical company. Okay, now let's put this all together in a simple way that we can memorize it, and ace the PMHNP board certification. So here is my narrative that I created, and hopefully it will help you. If it does, keep it. If it doesn't, throw away. So in this narrative, I try to associate things so that way it's easier for me to remember. So here we are in the land of the national health metropolis. A renowned judge named Tor Bifus upheld the law with a just and fair hand. His rulings were always guided by the principle that formed the acronym Torpedes Fuss. Torpedes Fuss. And the T stands for the Tarasov principle. The judge Pete Fuss always reminded the down people of their duty to warn others if someone possessing imminent dangers, reflecting the Tarasov principle. The H for torpedes fuss is for the habeas corpus concept, which is nothing less than he protects citizens from being unlawfully detained without due process, ensuring that liberty, mental health were safeguarded. Well, what about the O? You know the O. The O is for O'Connor, right? In his courtroom, the judge Pete Fuss decreed that mental illness alone could not justify involuntary hospitalization, echoing the verdict from O'Connor versus Donaldson. How about the R? Is the rights. He championed patients' right, insisting on the least restrictive environment and informed consent for all treatment. Okay? Don't forget confidentiality to the rights there. Prefuses. The judge Prefus upheld the right to refuse treatment as signified by Rayner versus Claim and ensure citizens could appeal decisions. Durham, he ruled that individuals were not criminally responsible if their unlawful act was the product of mental disease, such as in German versus USA cases. What else? What else are we missing? The Ford, the F for the Ford. The judge Pidfas declared that a person must be competent to face execution, aligned with the decision in the Ford versus Wainwright's case. How about the self refer? What does it stand for? He was strict against self referencing for profit, upholding the Stark law to prevent conflict of interest in healthcare. The S for sample, the judge PFAS was a vigilance against the influence of pharmaceutical companies, prohibiting practice that could lead to conflict of interest. Remember, the just in principle judge toward PFAS and the torpedo fast principle can help you recall the essential legal proceedings and protection in mental health cases, right? Litigations. Now, don't forget about prejudice, right? Which is also lying under the court law. So prejudice is another case that you need to know, although it's not on my presentation today. So now let's see what we learned. Let's do a check on learning so we can finally get a little bit more understanding on the question formats here. In a recent outpatient consultation with the PMHNP, a patient displayed aggressive behaviors towards his boss during a heated argument that escalated into a physical violence. The patient later expressed an intention to cause harm to his boss upon returning to work. What would be your appropriate action as the PMHNP in this case? What would you do? A. Reach out to the patient's employer to address the potential for dangerous behavior. B. Ensure that the patient agrees to a non-harm agreement. Does it sound good or not? C. Formally discourage the patient from contacting his boss. Or D. Consult with your state board of nursing to assess potential risks. I trust that you got this question right, because we covered this principle or these type of questions in the beginning of this presentation, and therefore you got it correct, right? D, consult with your state board of nursing to assess potential risk. Okay, so if you never took a PMHNP review course, it's likely that this does not sound like a good answer, right? But now that you do, now that you are with us, we want to emphasize that contacting the state board of nursing or contacting the police likely is the possible correct answer. Another checking and learning here. So, in a routine follow-up session with a PMHNP, a patient informs the practitioner that her spouse has expressed a desire to end his life while at work. The PMHNP first course of action should be: alert the husband's employer. B. Informing the husband relative. C. Advising the patient to check with her husband. Or D. Contacting the local authorities to report the potential dangers. Again, same principle applies. Different question, different wording, but contacting your local authorities to report the potential dangers is the correct answer. So let's look back at those other possible answers. A. Alerting the husband employer. Well, what if the husband employer doesn't do anything or just said, nah, he's not going to do anything, I will just stay here and they'll carry on my day, and something happens, right? Informing the husband relative. What if the husband relative shrugs off and do nothing? Advising the patient to check on her husband could be okay, but again, could put the patient in harm, it could put others in harm. The most appropriate, the best answer choice is the contacting the local authority to report the patient the potential dangers, right? And again, you can never be wrong with calling the police. There could be other better options, but you can never be wrong with the calling of the police. Is your right. You can do so. You don't need no one's permission, and there's always a safety bet to do that. All right, another check on learning. So, if a patient has been involuntarily hospitalized and refused to take his medication, what courses of actions should be taken? A. A psychiatric patient in a involuntary status cannot refuse medication. B. A psychiatric patient do not understand what is best for themselves. Or C. A psychiatric patient can refuse medication even if in a involuntary status. D. A nurse must use sound clinical judgment and insist the patient should take his prescribed medication. Take it a minute, read it again, and pick the best option. Well, guys, we hopped on this principle, so I hope it's making a little bit more sense of how the board wants you to think. When you become a PMHNP board certified, you follow what your local state nursing board state nursing and your local hospital policy. But for the test here, that answer is psychiatric patients can refuse medication even if in involuntary um, status. Okay, so I hope this was somewhat helpful to you. If there is a better way to explain, or if there is a better acronym, I love acronyms. Okay, so if there is a better one, please share with me. I would love to know from you. My name is Dr. Lopez, and I can't wait to see you become the next PMHNP board certified. Bye bye.